10 seconds, 5 seconds, start. Further, alike international banks, the banks and financial institutions in India do not have power to take possessions on securities and sell them. Our existing legal framework relating to commercial transactions has not kept pace with the changing commercial practices and financial sector reforms. This has resulted in slow pace of recovery of defaulting loans and mounting levels of non-performing assets of banks and financial institutions. Narasimha Committee 1 and 2, constituted by the central government for the purpose of examining banking sector reforms, have considered the need for changes in the legal system in respect of these areas. In another case, referring to the statement of objects and reasons, this court dealt with the submission that existing rights of private parties under a contract cannot be interfered with, more particularly putting one party in an advantageous position over the other. In that context, the three-judge bench observed, as discussed earlier as well, it may be observed that though the transaction may have the character of a private contract, yet the question of great importance behind such transaction as a whole, having far-reaching effect on the economy of the country, cannot be ignored. Purely restricting it to individual transactions, more particularly when financing is through banks and institutions utilizing the money for the people in general, namely the depositors in the banks, and public money at the disposal of the financial institutions. It therefore appears that one of the main objectives behind the incorporation of Prasar Bharati is to provide an adequate coverage to sports and games for the purpose already noticed. Specific notice would be required to be taken in the light of the contentions advanced, which will be noticed later, of the provisions contained in section 12 of the Prasar Bharati Act 1990, which enable the Prasar Bharati to negotiate for purchase of or otherwise acquire programs and rights or privileges in respect of sports and other events, films, serials, occasions, meetings, functions, or incidents of public interest for broadcasting, and to establish procedures for the allocation of such programs, rights, or privileges to the services. We may now turn to the provisions of the Cable Act 1995. The object of the Cable Act 1995, as indicated in the preamble, is to regulate the operation of the cable television networks in the country, and for matters connected therewith or incidental thereto. Section 3 of the Cable Act 1995 stipulates the necessity of registration as a cable operator in order to operate a cable television network. Section 2 defines cable operator in the following terms. 2 cable operator means any person who provides cable service through a cable television network or otherwise control or is responsible for the management and operation of a cable television network and fulfills the prescribed eligibility criteria, and Section 8 of the Cable Act 1995 permits the central government to specify the names of Doordarshan channels or the channels operated by or on behalf of the Parliament which are required to be mandatorily carried by the cable operators.